don't suggest this is a rule. You don't suggest this is a rule of the city council.
I don't know what it is. It's a long-standing practice. But we attached to our reply memorandum, which we did not have when we filed our original memorandum, a document that was a report of an independent commission appointed by the city council in 2004 or 2005 that recommended that in this very instance of a development that adjoins another district, that the city council change its rules, or whatever you call it, changes its practice. The city council in the 12 years since then has done nothing about that. Nothing about it. Now let me get to my main concern here. The practice of councilmanic courtesy, Your Honor, we believe is a pernicious one. In this instance, what happened was the evidence is set forth, I think in tab 7 of our notebook, that the councilman for District 5 was elected. It was his first term, and his major financial support came about through efforts of the developer. Sure, the developer had no idea as to whether his man would win or not, but he did win, and there was nothing wrong with making those contributions. Citizens United guarantees that. But the issue here is whether there is an appearance of impropriety. That's the language used by the Court of Appeals in Maryland in the Regan case. There's an appearance of impropriety. And what we have now in the city is this, I would call it an insane system, where one individual controls essentially the legislative, the executive, and the judicial parts of our government when it comes to a development. The legislative, because the city council members, just as a matter of course, voted in accordance with what that councilperson wants. When I was making my presentation before the land use committee, I started to get into councilmanic courtesy, Your Honor. The chairman cut me off. He said, let's not go there, okay? They don't want this system to end, but we contend that it's unconstitutional. That's the legislative branch. The executive branch. Why does the planning commission not give notice to these people who live down in Cross Keys and Harper House and these houses right up here next to Northern Parkway on top of a hill that unfortunately are going to overlook this 80-foot high building? But they never asked, the planning commission never asked whether an 80-foot tall building would have any impact on the value of these homes. Never. It makes no sense at all. As far as that's the executive branch. The judicial branch, well, the city council in this instance is acting as a quasi-judicial body. It's just wrong, and we believe it's unconstitutional to give one individual in this government all that power. It makes no sense, and it leads to very bad things.
So part of the city's argument on this point is that only one council member at the committee hearing made comments that would support a conclusion that that council person was voting based on courtesy, and that there were 6 votes in favor. So that even if we discount that vote, there's no showing that this outcome was dictated by that policy.
Your Honor, that's why in our reply memorandum we said that according to the land use article adopted by the General Assembly, the court can take additional evidence. And what we would like to do, if the court will grant this request, as we said in our memorandum, if you want us to make a formal written motion, we can do it. We would like to depose various members of the city administration to find out what exactly goes on. There are, I will say, people who have talked to city councilmen who have acknowledged, yes, this exists. If you scratch my back, I'll scratch yours. That's not the way deliberation is supposed to work. had a supermajority rule. You had to have a supermajority in a council meeting or whatever it was in order to pass a rezoning. The Court of Appeals struck that down. They said that basically implicit in the land use article, which governs everything involving zoning, is that it's a majority vote. Well, here it's not a majority vote. The other thing gets to what you were asking about. There's a sad aspect to this practice. I hope that the court hasn't read Councilman Dorsey's testimony and his questions. He, right after the developer testified, he was challenging the developer about why is this building going to appeal only to people whose incomes are $75,000 to $150,000? We have a city of homelessness. We have a terrible situation with respect to homeless people. We have a terrible situation with respect to poor people. Who can afford to move into this building? And then later on, after just before the final vote was taken, about 70 pages later, he called this ordinance inherently structurally exclusive. We are a city that suffers significant negative impacts due to development, both at private level and public infrastructure, which encourages car dependency. The development, he said, is, quote, irresponsibly myopic in scope, and he added, it perpetuates racial segregation and is in effect structurally racist. End quote. He felt constrained to vote for this because of councilmanic courtesy. Now, I haven't talked to him about it, or why else would somebody make this comment if councilmanic courtesy was not in existence? And I think it's sad to put councilmen into this position where they can't be honest and frank when they cast their votes.
So there really isn't any conclusion that is permissible other than the obvious one that they adopted the Planning Commission's recommendation. And certainly these agency reports are not unassailable, and they're not per se substantial evidence, and indeed it's the petitioner's role as the opposition at the hearing to assail the evidence, and they were given the opportunity to do so. They testified to their counter expert on the traffic matter and to other evidence that they had in their binder. And it's the council's job as the finder of fact in the administrative quasi-judicial proceeding to weigh the evidence as it sees fit, and clearly they assign more weight to their own planning commission, who I recommend.
What if they don't have the opportunity to weigh it?
I'm sorry?
What if because of time they don't have the opportunity to weigh it? They get a 600-page binder at the beginning of the hearing, and the most a council member has the opportunity to do is leaf through it during the hearing.
Right. So I would think that, well, first of all, they were given 45, well, in the end, they were given 45 minutes to testify to the portions of the binder that they deemed the most important, and indeed, they're the very same. We pointed to them in our brief, the instances where they did talk about them, and they even referred to them. It's, I can't remember the exact thing, but it was, it's tab 3C in our binder that says this. So in this case, they were given sufficient time to weigh it and to entertain testimony to those sources of evidence. Further, I think if I were to come in here with 600 pages of records and ask Your Honor or ask any judge in this building to read it all, I would expect that you might say, well, can you summarize it for me? And that's indeed what happened, and they were given the opportunity to summarize the evidence and to testify to those portions that they deemed most important.
But it seems to me the only way I can construe that in terms of considering it, where it's been accepted, it's not that the administrative body says, oh, too late, we're not taking this into evidence, but it's accepted for consideration. Then the only way I can view that is that based on the summary of it, the council members said, not good enough for me to look at it more closely. You know, I don't need to read Mr. Motz's analysis or the traffic expert's analysis because I don't think it's sufficient to overcome what I know with maybe more preparation from the Planning Commission. Because it just doesn't seem realistic to think that that any council member spent any amount of time looking into that contrary evidence.
I do think it's worth noting that Petitioner's Counsel here today did say they dropped it off several hours before, so that it's not as though they just gave it to them on the bench at the trial. So there was, it's not, you know, it's not that it was just 45 minutes and that was it and they had to read it while they were talking. They did have some time, but you know, certainly if they haven't pointed to a you know, source of law that says that, you know, if you just drop off a bunch of papers, then, you know, it demands a recess, and you have to, you know, you have to wait several days as long as it takes to read 600 pages of material.
Well, I mean, I'm concerned about that, but another approach to it would be to, for example, cut off the submission of evidence, except in unusual circumstances, at the Planning Commission stage, so that the Planning Commission staff can say as part of their report, we have considered the traffic expert of the opponents. We've analyzed it. Here's the problem with it. Here's why we adhere to our view. And then that way, at least the council members can, in receiving that recommendation, have some confidence that other people have gone through the detail of it. Right. But as it is, it creates in citizens the impression that it's not considered.
Well, that would be one way to handle it, and you know, I certainly wouldn't advise against it. I think that would be a good way to handle it. However, that's not, there's no procedure anywhere or statute or council rule that says that that's the way it has to be done. So I would imagine that if they showed up at the day of the hearing with 600 pages and the council had denied admission of it into the record, then that would give rise to a completely separate cause of action under due process concerns.
Sure, depending on what the rules were. I mean, if the rules said submit any evidence 10 days ahead,
right,
then there'd be a rule against that submission at the hearing. I mean, I fully recognize that the council committee is balancing the need to have a public hearing and to have not to put the rules of litigation onto this proceeding, but at the same time to have a meaningful, what is, I mean, everyone here concedes it's a quasi-judicial hearing. It is not a legislative hearing.
Right, and I think as you indicated, ideally, you know, at what point do we, at what point do we impose the rules of litigation? Yeah, there's a complaint that, you know, we didn't get the traffic report until a few days before, but, you know, this isn't, you know, it is a quasi-judicial hearing. It's not a full-blown trial. There aren't rules of discovery that guide the process, and the council has to sit in its quasi-judicial fashion and accept evidence and accept testimony. And in the city's view, they had plenty of opportunity to testify to that evidence. And on the issue of Councilmanic courtesy, Your Honor did point to our argument. Essentially, the evidence in the record that goes to this is one councilwoman's utterance saying, you know, deferring to another council member's view. But again, there's case law, there's even Supreme Court guidance on this point that what motivates one legislator is not necessarily what motivates others to enact it, and the stakes are sufficiently high for us to issue guesswork. And that's from United States versus O'Brien, and this this particularly comes up with issues of constitutional challenges to statutes, where the utterances of certain congressmen or legislators are trying to be used as
in a legislative process.
I'm sorry?
In a legislative process,
yes.
Not in a quasi-judicial process.
I'm sorry, I don't.
If your decision maker in a quasi-judicial process is a panel of people, it's no longer a panel if they all follow one vote.
Right, but there's no evidence of that in this case. There's an utterance of one council member who said this, and to your point of a legislative setting versus a quasi-judicial setting, the courts in Maryland have applied that principle to that instance in the case of Pack Shack Incorporated versus Howard County, where the court said even if one council member's motive was illicit, a single legislator's motive is not sufficient to invalidate the ordinance. So that's essentially that's what this ends up being. It is a quasi-judicial proceeding, but it ends up as an ordinance, which is a piece of legislation.
Well, but the process, I mean, I think no one, even the developer, is arguing against overpack that this is a quasi-judicial process.
Right.
It is done by legislators, but it's done by them sitting in a quasi-judicial capacity.
Right.
It results in an ordinance, but that is almost, in fact, I think, the contrary would help Mr. Holzer's argument to say an ordinance is not an application. That this is essentially a conditional use type proceeding. Just happens in front of the city council rather than in front of the zoning administrator.
Right, and they vote for the ordinance. So
but they don't vote legislatively. They vote as decision makers.
Right, as one. So
supposedly principled decision makers applying law to fact.
Right. And in this case, it's an instance of one person on that panel saying this, and it's not. Council has made these broad sweeping statements about this is what we all do. I mean, this is what the city does, and it's well known to everybody. But there's just no basis for that. This is all based on one sentence, that utterance can so infect the rest of the panel so as to just bring the whole decision down, because I understand your point about that it becomes legislation and it's not. It is a quasi-judicial setting, but they do so by voicing their own opinion, and they either pass it or they don't pass it by vote. So even if we were as we said in our brief, even if we were to discount her vote, then we would still have 5-0 unanimously. So it's just not present here.
I'll be the devil's advocate, but some would say it's not stated. It may be present, just not stated.
Well, okay. There's no basis for concluding that, and this is a record appeal, and the court's role is to review the record down below, including the statements made by the council members as they were voting on this ordinance. So,
I fully accept that many council members could say, I don't like this development. I think it's a good idea, but it's supported by the law. And that would be a principled approach to say, we have a structure for considering this. I've heard facts. I accept the Planning Commission's recommendation, and I wouldn't do it, but it's appropriate to approve it, and that's a principled approach. The concern is whether what's actually happening is that it has a sponsor and that others are deferring to that sponsor.
Right, and many members of the committee did say that, as you just suggested. I referenced Councilman Dorsey's explanation for his vote, where he said, I've got issues about parking. My big issue is, one of my campaign issues essentially is is public transit, and I want to increase bike infrastructure. So I've got some issues about parking spaces. I wish there were less parking spaces, but however, I still have faith in the agencies who have reported here today that this was that this met all the standards of the zoning code regarding PUDs. So many did. The only evidence we have to suggest that this practice was going on, again, is just on one of the members.